Some people think that once I register a trademark, I own that name for everything. And that's absolutely false. It is, the USPTO has 45 different international classes. They call it international classes because they share the same classes with a host of other countries. And they've all agreed, okay, these are the classes. These are the 45 classes. The first 34 are products, goods, and the last 10 are services. And you have to select which goods or services your product will be registered under. Somebody may be saying, I'm going to sell everything. Well, when you do have to file for all of those classes and pay for those classes with the U.S. Patent and Trademark Office. If you want to see what that filing looks like, just look at any Disney filing. You'll see a ton of different classes.
Welcome to the Clear Brand Marketing Podcast, where we take the mystery out of marketing and help you get more leads and sales with a clear brand and proven marketing tactics. I'm your host, Alexander.
Today I'm joined by JJ Lee. He is the founder of the Trademark Lawyer Law Firm, PLLC in Ann Arbor, Michigan. JJ Lee has been practicing trademark law for over 15 years and has successfully registered over 7,000 trademarks with the U.S. Patent and Trademark Office and internationally. He's joined us today because he's excited and loves helping entrepreneurs protect their brands and grow their businesses. Welcome to the podcast, JJ.
Oh, pleasure being here. Thank you for inviting me. This is an honor.
I am excited to have this conversation because I think that trademarks are often an overlooked part of branding, which I'm sure that we're going to get into. I don't want to start a monologue on trademarks here when we have the expert himself. So I just want to actually just jump straight in. Why don't you just give us a little intro to trademarks, what they are, purpose, how we can use them.
Yeah, absolutely. Trademark is really just protecting the brand. It is the mark of the trade. And typically when it first started, I think it was just branding on a cattle. This specific brand on a cattle means that this is owned by this particular rancher. And so I wouldn't say it started with that, but that's an association of how you can understand trademarks. I mean, there's been trademarks back in the ages where people would identify who the origin of the goods or services are, because their reputation depends on it. And people buy from people's reputation, not always from the product itself, but the reputation of the maker. And trademarks really is a source identifier of goods and services. That's different than patents, which is a mechanical design meant to protect devices and gadgets and copyright is a protection of the original work, like and put on some sort of permanent form like movies, podcasts, etc. Or trademark is strictly commerce. It's actually regulated by the U.S. Commerce Department because that's the only way you can actually have a trademark protection is to have it in use in commerce. You can't reserve it. You can't say, I like this name, I'm just going to keep it in reservation. In fact, 3 years of non-use is considered abandoned by trademark law. And so you have to prove otherwise. Yeah, right. So you don't have very much time to say you're still using it in commerce. You have to constantly use a mark in commerce. And the USPTO has taken numerous steps to get rid of what they call deadwood of registrations, because it's what is the statistics? Businesses typically don't make it past the 5-year mark, and definitely a lot of them don't make it past the 10-year mark. And so at that point, the USPTO, well, we'll start with trademark registrations are renewable every 10 years, but the USPTO has noticed that there's a lot of trademarks that were dead wood, so they instituted something called Section 8 filing between the 5th and 6th year anniversary. The reason for that is just get rid of a lot of trademarks that are no longer being used in commerce and open it up for people who are actually using it in commerce. So it is an identifier of goods and services.
Okay, so you had used the definition there of kind of branding cattle, which I've heard a variety of designers and different people in marketing use that exact same example for branding itself, company name and things. So what is the risk? It's the same thing here. What you're saying is with a trademark, you own it. Is that what I'm hearing?
With a trademark, by the very fact that you're using it in commerce, you own it. The question is, where is that extent of that ownership? Where does it start conflicting with somebody else's ownership of their trademark, or will it cause confusion in somebody else's trademark? Common law trademark rights refers to these, which is your use of a trademark in your area. Now, we're talking about small businesses. Let's say you have a barbershop. You don't expect to move out of the state or even that town, or even a cafe. You have a trademark that you own just from the very fact that you're using it. Now, somebody else may file and register a trademark with the U.S. Patent and Trademark Office, but trademark law favors usage. So if you use it before anybody else has filed or used it in other areas, you still have ownership to it. They can't tell you to stop using it. It becomes more difficult when you say, my barbershop is doing great. I'm going to sell my barbershop name brand products all across the U.S. Now, if somebody registered that trademark and you're expanding outside of your current scope of influence, then it becomes problematic, and then that's where we run into conflicts. But you own a trademark from the very fact that you're using it. The question is, are you conflicting with somebody else's, or have you used it prior to anybody else?
So let me make sure I'm understanding here. So let's say Clear Brand is the name of our company, and by using that name and logo, there is kind of almost an unofficial ownership to that. And as long as it's not challenged, maybe it doesn't matter a ton, is kind of what I'm hearing. But the trademark there is to add some of that certainty and that legal authority in case, let's say, another marketing agency decided to call themselves Clear Brand. Is that kind of what you're saying? If without the challenge, it's not a big deal. You being local is fine, but it's when it goes bigger and others are trying to use it.
Right. And so the purpose of registering it is once you register it with the U.S. Patent and Trademark Office, it gives you instant nationwide protection. And what it does, it gives you that protection. It also enables somebody else to be aware and give them notice that you are using the trademark. I just went on a call with a client, and she was thinking about, hey, how about this combination of word for my consulting services? We just looked it up, and it was used, it was already registered. So that's an instant notification to her to say, well, let's stay off of that name, not use that one, and let's think about something else. But I didn't mention to her, look, they have a renewal deadline in 2028. Let's revisit it then, because you have to still use it in commerce in order to maintain it. They may no longer be using it at that point, but it gives a warning to somebody else that you're using it. The trademark application process does that vetting for you. You file the application. It takes about 6 to 8 months before the USPTO reviews it. They review it. They look at applications to see if it causes likelihood of confusion with anybody else. After they said, oh, okay, we're good with this, then it goes through publication for opposition. This is where a third party can also choose to oppose your registration because they think it's too close to yours. Even though the USPTO says it's fine, they may say it's too close. So one classic example I love to give is when Toys R Us was still around. The Jeffrey Company, which is the holding company's name, used to oppose anybody with R Us. I mean, the USPTO said, fine, you want to do lamps R Us? That's fine. There's no conflict with toys. But the Jeffrey Company would always oppose any application that would have the R Us, and they were very successful at it. I don't know how diligent they are now since that's gone under, but but that was one of those that they protected because they thought it was too close, and they wanted to protect the R Us brand.
I mean, that makes sense because I think that they were doing like Babies R Us and things.
Yes.
I've heard that Apple will oppose all fruits. I don't know if that's true.
Well, it depends what the fruit is for. If it's for computers, probably. Computer devices, probably. If it's for I've seen bedding and home furniture with fruit names. I think they're staying out of. I'll probably do a quick search and probably find other fruits. It's financial.
Kind of the industry and the use is a big part of it.
Exactly. And so when you register it, and thank you for bringing that. That's a great segue. Which is, some people think that once I register a trademark, I own that name for everything, and that's absolutely false. It is. The USPTO has 45 different international classes. They call it international classes because they share the same classes with a host of other countries. And they've all agreed, okay, these are the classes. These are the 45 classes. The first 34 are are products, goods, and the last 10 are services. And you have to select which goods or services your product will be registering under. Somebody may be saying, I'm going to sell everything. Well, when you do have to file for all of those classes and pay for those classes with the U.S. Patent and Trademark Office. If you want to see what that filing looks like, just look at any Disney filing. You'll see a ton of different classes, and some that they decided not to proceed forward with because it didn't make sense as a brand. But yes, you are selecting the specific goods or services that you're registering under, and your protection's limited to that and the related services or goods. And what I mean by related services or goods,
with Disney, Marvel would have to have all sorts of protections because they've got movies, comic books, toys, video games.
Yes.
They've got the rides and the different parts of the theme park.
Yes.
And each of those would need its own separate protection.
Correct. They have separate filings and separate classifications that they would register that under. Yeah, for sure.
Wow. So what would be the likelihood if somebody else decides to, you've been building this brand, right? You've been listening to all the advice of the marketers out there, and you're building this brand, and it's not trademarked. What are the risks there?
The risk is that you would have to fight multiple fronts. And that's the biggest
so somebody
risk.
could potentially bring some legal battle to take over that name.
Take over that name, or you would have to fight everybody on different fronts by saying, sorry, we're using this in this front, we're using this in this front, this class. You also run the risk, if it's not registered, the USPTO will allow that name to be registered by another party. Mm-hmm. And that is not worth letting go or not filing. Yeah, it may be a couple thousand to register it, but it is 50 to 100,000 or more just to try to enforce what you should have registered in the first place.
So if somebody else kind of beats us to it, it might cost more money to go fight them for it or to rebrand if you decide not to fight,
right?
Than to just get it in the first place.
Yeah, you have two paths right there, and you mentioned both of them. If you are the rightful owner, you have prior use, you have to fight them to get it back from them, and that costs a lot more money than trying to file and register a trademark. The other thing is, if you're not the first and you don't have priority, they actually do, then yes, the cost of rebranding everything is, just as much or more than, way more than just filing and registering a trademark. So
that's a great point. This should be the foundation of any branding conversation, would be trademarks. Because, a lot of folks, we've talked to a lot of folks who are launching a business. We've helped folks launch companies. And most of the time when they're naming their business, they're looking at, does this sound cool? Is the .com URL available? And that's kind of it. But really, they should be going a step further and checking to see what's already been trademarked if they're going to go buy the .com. Because sometimes a good URL, a good domain name can be thousands of dollars.
Right.
So they might as well go check and make sure that the trademark's not taken before investing all that time and energy in it.
Yeah. And can I mention something along that too, is that let's say you do pay a couple $1,000s for that trademark, or for that domain name. If it's already a registered trademark, I've done it. I could transfer that to the original owner. I could file a UDRP saying that you're violating this person's trademark, and I could transfer that over. So
wait, let me make sure I'm hearing you. So you're saying if, we've got, when we launched ClearBrand, we did not own clearbrand.com at the time. Let's say, hypothetically, we trademark ClearBrand. We could then go after the person who's using clearbrand.com. Is that what you're saying?
You can, but it plays around with really who came first. If you filed the application and registration for the trademark for ClearBrand, and somebody filed the domain registration after that, then yeah, that's an easy path. If they actually had the domain name prior to you filing and registering a trademark, that is a much more difficult obstacle.
But if they bought it after we had the trademark, or after we'd filed for the trademark, would we have to buy the domain from them, or would we just say, hey, this is ours?
Right. It depends on what they're using it for, but we can force them to transfer it. If they're using it in the same goods or services, yeah, there is a way to to file with the UDRP saying that they're infringing on your trademark and that you didn't give them rights to use it. They're using it in bad faith. But those are all actual questions that we have in mind. Did they know you existed? Did they know that you filed the application? Did they plan on it? Some cases it's really obvious that they're just imitating and copying everything. Those are easy cases to transfer over. If it's more of a factual matter, it becomes much more difficult, and it's not a clear path to transferring it over. So I don't want to say, yes, if you file it before and then they have the domain, can you transfer it over? If it's clearly that trying to imitate everything that you're doing and using it in bad faith and confusing your clients, yes, that's an easy transfer. If they're using it on their own terms, on their own brand that they have, it makes it much more difficult because they can actually file a rebuttal saying, no, I've never heard of these guys. This is my brand. We've been owning it since. And so then it becomes more of a factual question.
So a lot of it comes down to prior use. So it sounds like even if you kind of drag your feet on getting a trademark, if you're the first one to use this, then you've got some options and you can probably wiggle your way in there.
That's a great way to put it. If you have options and money, yes.
Options and
you
money.
You can get them back. Right.
So what do you think about Elon Musk rebranding Twitter as X? Is there any hope that he's going to get a trademark for X?
He has enough legal power, and there's also...
And enough money.
Enough money, right. And that really plays a part in it. In the association with that, there's so many legal angles to play with what he's doing. Not only the fact that in this specific area, I know Microsoft has a registration. I mean, it's not that broad when there's so many other X's that are coexisting in the same relative space. So you have to look at that as well. What is the consumer perception? Does it cause likelihood of confusion? When you look at that X versus Microsoft's X, are you thinking it's the same social media? So it all comes down to likelihood of confusion. And he has money, he has attorneys that can argue, or just by sheer willpower, just grind these things down where to a point where like, well, it doesn't make sense to argue this any further. We could just coexist together. So who knows where it'll end up, but it's a very distinctive X that's different than somebody else's X. Just because it's registered is not an absolute. And I think that's a great segue to say, just because you have a registered trademark, these are not all absolutes. It's a subjective process, completely subjective process, depending on which examining attorney you get, which judge you get. So you have to be vigilant about what you're protecting. And, sadly, we deal with small business clients. Sometimes, I tell my clients, I know these people are sending you cease and desist or telling you to stop. I know you're right. How much are you willing to spend to prove that you're right? And that's a tough question and tough conversation because I know my client's right or has priority. It's just, are you willing to go through this battle for a couple of years spending attorney fees just to prove that you're right? And, unfortunately, that's kind of the bully aspect of trademark enforcement.
So that kind of, X and Apple are interesting. If Apple, whether or not it's true, I don't know, but if they did decide to go after everybody who's using a fruit, it's not just, well, who's right? It's also, does this small company have the money
to fight,
to defend themselves?
Right.
Yeah, I was a little bit sad, but kind of not really, for the person who had owned the @X handle.
Oh.
And as far as I know, they just took it and gave the person some random.
Right. I know.
Too bad.
Right. What legal right do they have though? That's kind of, it is it's a difficult, you're on their platform at their permission, on their whim.
Right.
And I'm not saying that's right. I'm just saying, man, that's just, it's kind of how that world works.
So what are some interesting trademark cases that you've come across over the years?
So I was fortunate enough to actually, I was at the Supreme Court, the U.S. Supreme Court, near a time when they were doing the Jack Daniels case. And it's a very interesting case. Yeah, Jack Daniels, the bottle itself. There was a case against
the
VIP.
The bottle itself has a trademark?
The product of, the whiskey, Jack Daniel whiskey. VIP Products created this dog toy that looked just like the Jack Daniels bottle.
Huh.
And so the question was, does Jack Daniels has a right? Do they have a right of infringement against something?
Did it say Jack Daniels on it, or it was just the shape?
It didn't. It didn't say Jack Daniels. It said Bad Spaniels.
Oh, nice.
I mean,
okay.
And so the question is, will this cause confusion? It's not in the same realm. People are not just Jack Daniels have a right to enforce this against bad, VIP with bad spaniels. I mean, they did everything in terms of not copying their name directly, but the bottle looked like a Jack Daniels bottle as a dog toy.
Wow.
But regardless of which side you fall on, Jack Daniels did win. So there was an infringement case. Yeah, they did win on that case. So that's one of the most interesting ones.
They hadn't trademarked the bottle shape or anything.
That's a great question. That is a trade dress.
That's trademarkable.
Yeah, you can register that as a trade dress, and I'm pretty sure that they did. That's probably I'll have to look it up and confirm that. But that's
part of how they won.
Possibly part of how they won, and I should have looked that up. But I know I was just looking up another case, Bullet, with their the rye whiskey, also. So they actually have a trade dress on that, and they stopped somebody else from using something very similar because they have a registration on the bottle.
The bottle.
Yeah, on the look of the bottle. Nothing, no words at all that says Bullet. Just the shape of the bottle. So it is possible to register trade dresses like that. The Coca-Cola bottle is a classic example I give.
Yeah.
It's the shape of that bottle. And the Fiji water, which is in the news for not great reasons. But
I can't believe that a dog toy company fought Jack Daniels so hard that it went to the Supreme Court.
I know. It wasn't worth it. They were claiming, right. It went all the way up to the Supreme Court to see whether or not that level of infringement caused confusion. We'll reach out there. Their main defense was that it's a parody. Parody is funny because if it infringes in commerce, it actually so the U.S. government can limit commerce, and I think that's part of the main argument here is that trademark registration is commerce. Now, if you do a parody for something, an idea, or talking about somebody else, that's completely different. But if you're actually selling certain products that imitates somebody else's brand, and is it possible that Jack Daniels sells other products as well? They do, actually. They actually sell clothing and a host of other products as well. Is it possible for them to also extend out to dog chew toys to a point where
did they start selling dog toys after they won?
That's probably one of the things that they started putting out just so this won't ever happen again. But but this is a good lesson for everybody else. So on the one hand, it drives the fear of God into people making dog toys. Maybe we should stop doing that. And on the other hand, those people that they copy, now they're putting targets on these companies as well. So it's interesting to see what the fallout of this would be.
Wow. That's I mean, it's a funny joke. So tell me more about this parody, because I've wondered, and I don't know if this is an example, but SNL does parodies of real companies all the time, and they'll include real companies' logos. So is that allowed, or do they need to get permission from these companies?
No. They probably do those parodies on their own. But the question is, now will they start selling products with that logo or that parody on the goods or services? Now, if
but
they
them
start
just doing a video, I think Sydney Sweeney made a whole bunch of headlines when she was on SNL a couple months ago, and one of them was a Hooters thing, and they were wearing actual Hooters shirts.
Right.
Does that violate anything?
That would fall into parody. Now,
and that's allowed. They don't have to go to Hooters and get permission.
Exactly. Now, if if SNL started selling their own brand of Hooters branded stuff, that's where infringement happens, because they're actually using it in commerce versus freedom of speech kind of parody level, where that that is pretty untouchable right now, which is why they have free reins on doing parodies like that. But once they get to the point where they have an SNL version of these products, that's where Hooters can say, okay, cease and desist, stop selling these products. But that's not what they're doing. Yes, they're selling entertainment and they're selling ads and all that. Yeah, where is the limit of commerce? But in a sense, they're not selling their branded version of Hooters.
Right. So they can do those videos. They can talk about it in, whatever skit, but they just couldn't sell a knockoff Hooters shirt, basically.
Exactly.
Okay.
So that's where you get to the point where they could cause confusion in the marketplace by selling that branded shirt, or even dilution or even endorsement. Saying, oh, it looks like Hooters endorsed SNL to actually sell those products, and that's also a reason for causing or suing somebody else for infringement, is that there's no endorsement whatsoever. It makes appearance that Hooters allowed SNL to do it. So that's why SNL will not be selling any of those products. They have their own different products, but once they bring on somebody else's brand, then that becomes very legally risky.
So in the video, if they make it look like a company is endorsing something, does that put them at risk of infringement, or would that still just be considered? If they said, Levi's is doing this thing, is partnered with the devil and destroying the planet or something, is that still within parody limits, do you think? Or,
well, I guess really, what does the viewer think? Does the viewer think this is tongue-in-cheek parody, or do they actually really think? And if you do the survey and a poll, do people really think that the Levi's is actually endorsing it based on SNL? Now, if NBC News did that, it's different, because there's a different expectation that it's not a parody. Then they run into libel and other issues. But for SNL to do it, they mock so many different things that there's no expectation that any brand on there is actually endorsing anything on SNL.
Yeah, they had done a skit recently. I don't remember if they were using a real company's name, but I remember that they were making fun of some of these, supposedly sweatshop fast fashion clothing brands that are probably using some form of slave labor or very, very cheap labor to make this fast fashion clothing. And I mean, they were, I don't remember it exactly, but I don't think that they were taking direct aim at a specific company. But it sounds like because they're just known for parody, they can kind of do whatever they want. Yeah.
Right. As long as none of the things that they say are they state that are factually accurate, all of it runs into parody or a commentary, and it's not opinions and commentary, and that's allowed by free speech. That's not an issue. Yeah. It's only when you start selling products under that specific brand, or you claim that there's collaboration, that's when it becomes a problem.
Okay. Any other interesting stories about some trademark battles?
Well, there are some classic ones, I guess. When I say classic, so the word superhero, because I know that comes up quite a bit, is actually jointly owned by Marvel and DC Comics.
Really?
Yeah. You can jointly own names. So I don't know if you remember, but when The Incredibles came out, they didn't use the word superhero. They only call them supers, and because they couldn't. It's a registered trademark owned by Marvel and DC. This is before Disney owned them, but that's a funny fact. I know a lot of people start using the word superheroes now. It's very I don't envy their legal department to try to enforce these because it's difficult. But that is a registered trademark owned jointly by Marvel and DC, and they both can use it.
If there's a company, because there's a lot of companies that make comics, or I've seen there's some kind of cartoons on Amazon, and you've got what is it? Not the cartoon, it's the real one. It's The Boys on Amazon. They mostly call them soups.
They're avoiding Boys. That specific word because legally they can't use it.
Wow. Okay, I had no idea.
Yeah.
That's pretty crazy. So basically, any So what are the limits there? These companies that are making similar movies are avoiding the term.
Because they're using it in a movie context. Doesn't mean you
So
can't use it.
everything in like movie, TV context,
Yeah,
nobody
exactly.
can use the term superhero.
Exactly.
Wow. Man,
That's pretty powerful trademark to register, right?
Well, and that adds to the value when Disney buys Marvel or bought
Exactly.
Marvel.
Did you know after that they started using superhero all the time?
Because they got this trademark with
well,
it.
they got a free license to use it from Marvel from their ownership of it, right?
Wow. That's so that's actually an interesting point then. So tell me about how do trademarks impact the value of a business when it comes to selling?
Yeah, great question. That is a big question that people have to consider when selling their business, because a potential buyer will look to see the value of not only the business assets, but that also includes IP assets.
Mm-hmm.
It would be devastating to that buyer if they can't use that trademark for other things, or if it's not registered. That devalues that company, because otherwise, if you built all this goodwill under that brand, but it's not registered, you run the risk of potentially violation or infringement on somebody else's trademark. Now, this is a similar process that department stores use. If your clothing brand is not a registered trademark, they won't sell it. They won't brand it, because they don't want the liability of somebody else saying that you are selling a brand of clothing that I have ownership for. This is not an ownership. So we work with several clothing companies. They are waiting for a registered trademark so these other department stores will accept their clothing line. And so that's an important thing to consider. Also, if you're expanding on growing or expect to grow and franchise, it wasn't it was a prospect that I talked to, but this prospect was trying to get into various markets, but he didn't register his trademark, and there were already other similar names in different states. So how do you franchise something that, well, we can't use it in all states. We can't use it in most states. We can only use it in these states. So that becomes problematic. So if you are on a trajectory that's going to be a growth and expansion, trademark registration is vital. And your point is perfect, which is the brand of its. I mean, look at it. Toys R Us, the name is more important than all the assets of all the buildings. That's what sold the most, not all the assets when Toys R Us declared bankruptcy.
Wow.
That's how valuable the brand is.
So I had watched this, and this isn't exactly trademarks, but years ago, Motorola had sold their line of cell phones to Google, and Google made Motorola phones for a couple years, and then they sold it to Lenovo. And then Google launched the Pixel. And I had this suspicion that it was mostly about the IP. And it was interesting that Google didn't launch the Pixel until after they'd bought and then sold Motorola. So they must have held on to some of the patents and some of the IP behind the scenes, even though they let the name Motorola go.
Sometimes, yeah. Sometimes not sometimes. IPs are more valuable than a lot of the assets in many cases. So that's a sound theory. Yeah.
Got it. Yeah. Well, that goes back to the conversation beginning of this conversation here, where we were talking about branding and considering this trademarks from the start. A lot of folks, they don't start a business thinking I'm going to sell this. Some people do, but I think that this is kind of the point of the book, The E-Myth, which is a great book. The basic point is you should run your business as if you're going to sell it. Even if you don't sell it, you're going to be better off having run it in a way that it makes sense and that it could be sold, and that you have these systems in place and that you're paying the owners, for example. And it seems like this is kind of similar with branding. We should be considering the trademarks from the start. And, as we're building this brand, building in a way that could be more valuable if we ever decide to sell it. And if we don't decide to sell it, we still made better decisions because of the thought process. But if we do, man, having that trademark and building that up isn't going to hurt anything.
Right.
It's going to make
For
us better
sure.
off.
For sure. And I do, you know what, I don't know who said it, but you know, build it with the end in mind is exactly right. And I 100% agree with that. It also focuses you on, you know, I don't think people understand how important branding is. And I love what Alex Hormozy just came to his conversion, which is you don't need a brand. All you have to do is go through these selling processes but he admits that was the wrong way of thinking. The most important thing right now is the brand. That, and he well, happily, but he admits that he was completely wrong about that whole process. The long-term goal is the brand and growing the brand, because that's what grows. That's what 10X's your company. It's not the other systems. It's that people will trust, and like your brand. And that's why they come back to it. Yeah.
Yeah. That's interesting. And it's also indicative of the different phases of his journey. You know, when none of us know where we're going to be in 10 years. He initially made tons of money just by doing the work and selling stuff. And now he's got acquisition.com and he's buying businesses. So he's confronted each time with what is the value of the brand. So it's a brave and humble thing to do for him to admit that he was wrong on that.
Right. And it's teaching a lot of people on that regard too, which is so helpful, and it makes him a great thought leader in this process, because we can't relate to somebody who's always perfect, and he admits a lot of the failures that he's gone through, but he explains why. And I think he's in a much better place for it, because he admits that, man, branding is the game, you know, ultimately. And that's been my growth pattern as well. As I didn't realize personal branding was so important. And, you know, any branding related, for the longest time in my own personal growth, I just thought, you know, as long as you're good at something, people will find you. But that's not always the case. You can be the best at everything, but if nobody knows or aware of you or can't differentiate you from anybody else, that makes it very difficult to grow your audience and grow your business. Because if you look like somebody else, just like exactly the same as anybody else, then what makes you more distinctive? And branding does that. If they know, like, and trust that brand, that's what helps you to grow. And that's what also brings repeat business too. Hey, go to Alexander about this. I know him, I trust him, and I like him. And, you know, this is why people have built brands. And Clear Brand, it's one of those that people could talk about and say, this is a great brand. You know, otherwise there are so many other SEO web companies and marketing companies out there. There are a ton of them, but it's the one that you trust, and because of the brand, that's what makes them distinctive.
Absolutely. I mean, I think that we all like to think that we're very rational, but a lot of times the decisions are made before the brain even engages, you know.
Emotional.
So, yeah.
It's completely emotional. And then we try to justify it through logic, right? Why we do it.
Yeah. And so that's where we need to have both. We need to be able to provide people with the ability to justify this decision that they already made, even though they don't always know that they already made it. But we also need to be hitting that emotional side. You know, I think what you're saying is a great example. There's thousands of marketing agencies out there, and if you were to compare them on paper, it would be very difficult to differentiate them. And that's branding. Yeah, I think you're spot on. Yeah. So how do you go about, what is the process to get a trademark?
The process going in trademark, for us, what we do, we recommend highly to do a search prior to registration or application. The reason is, once you file the application, you can't change much. In fact, if there's any material alteration to the application itself, or you try to expand the goods or services, it becomes problematic. There's so many times where we saved our clients tons of money because we did the search and we're like, no way, there's no way this is going to get registered, or there's high risk that this is going to get refused. The problem with the current system right now is, you know, if the USPTO got back to us within a month, it's no problem filing something and trying it. We're not hearing back from them for 8 months. That's a lot of time to commit to marketing, to development of your company and your brand. And you don't want to start all over after almost a year of developing these things. So what we try to do is beat the process by doing the search up front and looking through what's out there, and then kind of going with some advice that we give in terms of how do you make your application stronger for registration process, or what we can do to kind of avoid some of these conflicts. And so many times that has saved our clients' application, and they've actually successfully gotten registered. So we would do that first. Once we're both happy, or they're willing to take the risk of, sometimes they do say that, let's just go for it. And, I'm so grateful for the times that it's worked. And sometimes when it doesn't, then, there's frustration there, especially because we already warned them about it. But, there's always a calculated risk for any legal filing anyways. But once it's filed with the trademark office, then you get a serial number, and then it's just hurry up and wait for them to review it. And again, it takes about 6 to 8 months before they review it. Then if there are outstanding issues in the application, they send out what's known as an office action. If everything looks good, then it goes on to publication for opposition. Publication for opposition is where a third party can oppose your registration if they think if it causes conflict. If that's cleared and there's no publication for opposition, then you get registered, and then you're set there.
Okay, that's sounds like a lot of work.
I can't tell you how many little things have thrown off a trademark application for reaching registration. It's so many little nuances. It is a lot of work and a lot of experiential data and information that people don't always have access to because they don't do it all the time. Now, can anyone file a trademark application? Absolutely. You can file a trademark application. I can file an application for Apple Computer. And will the USPTO take my money? Happily. They'll happily take all my money for anything. I'll file an application for Nike, for shoes, and they'll take my money.
And they'll just let you pay them.
Exactly. And they'll happily take my money. They'll just tell me 8 months later, sorry, you can't get it registered. So there's so many subtle, there's a lot of trademark filing companies, and those are, okay, let me put it this way. We built our law firm on fixing those problems that these other trademark. Yeah, exactly. That's how our law firm has grown. And that's how we successfully registered over 7,000 trademark registrations. It's because we helped fix those problems. We did not file those. And unfortunately, so many times we had to tell the applicants, sorry, there's nothing we can do. This is completely messed up. You put it in the wrong class. You put in the wrong description. You can't word it this way. And your owner is wrong or whatever. There's so many ways to go wrong that we tell them it's not worth spending money to try to fix it because nobody can fix it. We've said that too many times.
Yeah, but in one of our first conversations, so we had hired an attorney to submit our trademark application. It came back, somebody else already had it, and they said, "Hey, you're out of luck." And we were having a conversation. You said, "Well, hold on, let me look this up." And you looked at it and you said, "Oh, you've got prior use. I can totally get this for you." So sometimes it's the opposite of what you had just described, where somebody else told them you're out of luck, and you see a path through there.
Right. So it just depends on it depends on the facts and depends on the application. So some applications you can or you can't, but it really depends how much. When you do the stuff right up front and you get there early, then you minimize all the fixing that has to happen. It's just like a house or a car. You buy a new car or start new with something fresh. There's less maintenance or less fix up that you have to do to the car in order to have it reach its destination. And that's really what a trademark application is like. Is if somebody put it together crappy, and then along the way, I'm like, the engine's not going to make it. You put a crappy engine in there. There's no way it's going to make it. Or we could replace the lights. I know you got a ticket, but we could fix that and get you on your way. So it really depends on how well it's prepared, and timing is really all about timing. And I think, I'm sorry that you had to witness this, but you were not far off from the first filer of this. It was, I think, a matter of months. And I'm just like, and that is so frustrating where, we've actually seen applications filed the same week that our client was like 1 week before somebody else filed something. So, there's a bit of urgency there. We don't want to create false urgency, but at the same time, how hard is it to pull it from somebody else? It's difficult because they claim it first, and they may fight just as hard or harder to keep their trademark registration and application. So,
and then it sounds like there's a lot at stake, and especially if it's done wrong, you've got the extra cost, but you've also got that 8 months that you're going to have to wait to hear back, and all this time spent branding. So you might as well do it right the first time.
I agree.
It'll probably save money in the long run.
Yeah, right. And that's really it. You're spending quality. You're putting resource and quality filing up front to prevent issues, more issues and worse issues in the long run. Yes.
Yeah, it is the car. The car is such a good example. I kept following the advice of some money folks of like just buy an old beater, and I dumped so much money into fixing these old beaters that I had bought that I was doing the math one day, and I was like, a new car would be cheaper than this.
And that's you're doing a payoff right there. Are you paying? You're paying low up front, but you don't know when the monthly fee is going to happen. You don't know when because that's where all the payments happen. Versus you get a new car, you know when the monthly fees should happen, and it should be reliable without any issues that whole time. Right. So that's how I look at it. So I've never said no to other people getting a lease. I'm like, it really depends on the stage of life that you're in. If you need that car to be reliable and you can't absolutely have it break down for any reason or out of commission, that lease makes complete sense to get a new car because you know when the payments are, but the car is going to be reliable. Cost. Versus a beater, you're going to have to pay that monthly payment sometime. You don't know when it is. You don't know if it's going to be a lump sum of the whole year in one fixing. So I agree with you.
Absolutely. Awesome. So you've got me convinced here. I'm sure you've got some of our listeners convinced. So where can people find you if they're ready to get the help from an expert?
Yeah, absolutely. So our website is trademarklawyerfirm.com. But also I would highly suggest people sign up for our newsletter, which is TM Telegram. That's TM for trademark, telegram.com. And we send out a weekly newsletter. I just try to put as much information as possible. My experience has been, I'm happy to share as much experience. I can't give legal advice, but the more experience that I give to my clients and my prospects, the better they are with understanding. There's too much to learn, but the more they understand about trademarks, they can come to me with the right questions, the relevant questions for me to help them on their trademark journey. Yeah.
Awesome. So trademarklawyerfirm.com, and I have to ask, but you own the trademark for Trademark Lawyer Firm?
Yeah.
Okay. Of course.
We can't. We don't own Trademark Lawyer Firm. So we own the TM. We own that logo, and that's very interesting, right? Yeah, because Trademark Lawyer Firm is generic. You can't. It describes the services or goods, but that TM, we knew it's an interesting strategy because TM, you can't register it because it does stand for trademark. So we did a graphic intentionally, and we had to disclaim the words or the letters TM because we did not claim exclusive rights to use the word TM. We knew that up front, but it was one of those situations where we used our legal know-how to try to get our logo registered with the TM, where normally you can't with the letters TM by itself without the graphic. There's no way you can get that registered.
Well, and you got a great domain name, and you have the confidence to know that nobody's going to be able to take it from you because it's generic, so they're not going to be able to trademark that.
Exactly. As long as you know that going up front with this, and we did know that, but we did want to make sure that we had something distinctive, and that's what our logo was. But put that combination together, that's what we do is, what's a great strategy in the long term for protecting as much brand as we can legally as possible.
Yeah. That's awesome. Well, it's been great having you, JJ. Trademarklawyerfirm.com, and then the newsletter is tmtelegram.com.
Correct.
All right.
Yep.
Thanks.
All right. Thanks, Alexander. See you soon.
Thanks for listening to the Clear Brand Marketing Podcast. If you need help with your website or marketing, go to clearbrand.com. You can schedule a free strategy call with one of our consultants, or take advantage of our free resources to help you write, design, or implement a better website and marketing.